You've probably heard it. It's one of those rumors in U.S. immigration that just seems to hang around forever. If you live here for 10 years, you can get a green card. It sounds so simple, right? Almost like you've earned it. But is it actually true?
So let's just get right to it and ask the big question. Is this rule a fact, or is it pure fiction? I mean, for a lot of undocumented immigrants, the answer to that could literally change everything.
All right, let's dive in. When an immigration lawyer was asked this exact question, his answer was, the answer is yes and no. That's not exactly the clear-cut answer we were looking for, is it? But it's because the reality is so much more complicated than the rumor. Okay, so to really understand that yes and no, we have to push the myth aside and look at what's actually happening in the legal world. This so-called 10-year rule isn't a program you just apply for. It's actually a defense against deportation.
And this right here is the biggest point of confusion. What people think is that you can just proactively go and file some papers with immigration services. But the reality? This is a defensive move. It's something called cancellation of removal, and you can only use it as a shield to fight to stay in the U.S. after you're already in deportation proceedings.
So let me be super clear about this. You can't just walk into an office and ask for the 10-year green card. This option is only on the table for people who are already in immigration court, standing in front of a judge and trying to stop a deportation order.
Okay, so let's imagine someone is in that exact, incredibly stressful situation. To even have a shot at winning, they can't just point to a calendar. They have to clear 4 incredibly difficult legal hurdles.
So here they are, the big 4. First, you need 10 years of continuous physical presence in the country. Second, you have to prove you have good moral character. Third, you can't have any disqualifying criminal convictions. And finally, and this is a huge one, you have to prove that your deportation would cause exceptional and extremely unusual hardship to a very specific family member. And trust me, each one of these is a major obstacle.
Let's start with that 10-year requirement. This is where a lot of people get caught by something called the stop the clock rule. Just look at this timeline. Let's say you got here in 2016. You think, okay, 2026 is my 10-year mark. But what if immigration hands you a notice to appear in court in 2025? Well, your clock stops right then and there. It's frozen at 9 years. And just like that, you're no longer eligible.
And you know that word, continuous? They take that very, very seriously. If you leave the U.S. for just one trip that's longer than 90 days, or if you take a few trips that add up to more than 180 days, your continuous presence is considered broken. Game over for that requirement.
Okay, hurdle number 2, proving good moral character. A lot of this is up to the judge's discretion, but some things are automatic disqualifiers. They're called statutory bars. Things like, giving false testimony to try and get an immigration benefit, or spending 180 days or more in jail during that 10-year window.
And hurdle number 3 is closely related. You can't have been convicted of certain crimes. The list is long and it's serious. It includes things like an aggravated felony, pretty much any drug offense, firearms offenses, or crimes of domestic violence. Even just one of these convictions can make you permanently ineligible for this defense. So let's say you somehow manage to clear those first 3 hurdles. You now arrive at what is, for most people, the final boss battle, the hardest requirement to prove. We really need to break down what exceptional and extremely unusual hardship actually means. This isn't just a casual phrase. It's a very, very high legal bar. The law demands that you prove your family would suffer in a way that is substantially beyond the normal pain and difficulty of separation. The heartbreaking reality is that the emotional and financial pain that every family feels during a deportation, that's not considered enough to meet this standard.
And here's the absolute crucial point. The court is not focused on the hardship you would face. The hardship has to be proven for a qualifying relative. And that's a very specific legal term. We're talking about a spouse, a parent, or an unmarried child under 21 who's either a U.S. citizen or a legal permanent resident. If your closest family members don't have legal status, their suffering legally doesn't count for this defense.
So to pull this out of the legal jargon and into the real world, what kind of situations are we talking about? Think about a U.S. citizen child who has a really serious medical condition, who depends on you for care, and who couldn't get that same treatment in your home country. Or maybe you have elderly, permanent resident parents who are completely dependent on you for everything. We're talking about circumstances that are truly, well, exceptional. And this really is the heart of it all. The entire legal argument, your entire case, it all hangs on proving the profound and unique suffering your qualifying family members would go through if you were forced to leave the country.
So when you see all these hurdles laid out, you start to realize that trying for this defense isn't just filling out paperwork. It's a high-stakes legal gamble with absolutely everything on the line.
And hey, don't just take my word for it. Legal experts are clear on this. The Immigrant Legal Resource Center flat out warns lawyers that it's risky to put a client into removal proceedings to try for this, except in extremely strong cases. And why is that? Because if you lose, the consequence is deportation.
The odds are also just stacked against you. Congress has set an annual cap, and this is the number. Only 4,000 people across the entire United States can be granted this specific kind of relief each year. That is an incredibly small number when you think about how many people might need it.
So in the end, it all comes down to a coin flip with no middle ground. If you win, you get a green card. You get a chance to build a life here legally. But if you lose, you get a final order of deportation. In the end, the 10-year rule is a myth. What's real is a very narrow, incredibly difficult, and high-risk legal defense. It's not some benefit you earn, it's a last-ditch plea that's only available to a tiny number of people in truly desperate situations. And that leaves us with one final thought. Given the astronomical odds and the devastating cost of losing, is it a defense worth fighting for?